we know that the bar exam is racist. It's debated whether its intent is to be racist, but what is undebatable is that its effect is racist. And that's something that the NCBE has acknowledged in their April white paper. That's a non-starter for us. That's a non-starter for this profession that holds itself up to be one that promotes things like justice and equity and all things that are good in the world.
I'm Jack Newton, CEO of Clio, and this is the Daily Matters podcast. On Daily Matters, we talk with legal professionals, industry leaders, and subject matter experts about the future of law. We explore where the legal industry is headed, how legal practice is changing, and what you can be doing to position yourself for success. This episode of Daily Matters is brought to you by the 2020 Clio Cloud Conference, the world's best legal conference, which is going completely virtual for the first time ever. Get your pass now at cliocloudconference.com. Today's guests are Donna Saadati-Soto and Efrain Hudnell, co-founders of the grassroots organization United for Diploma Privilege, a national movement of law students, grads, law professors, and lawyers mobilizing in solidarity for diploma privilege for all, including LLMs and repeat takers. Donna and Efrain, thanks so much for joining us today.
Thank you so much for having us.
Yes, thank you so much.
So starting off, can you give us some background on United for Diploma Privilege and what the organization is trying to achieve? And for those of our listeners that are not aware, what does diploma privilege mean?
Absolutely. So diploma privilege is a way of getting licensure into the legal profession without having to take a bar exam. Now, whenever we say that, people get concerned, right? Because the bar exam is such a big part of the tradition of the legal profession. But It's important to note that, diploma privilege still requires you to go to law school. All right, you got to graduate. You have to meet all the requirements for your law school. But upon graduation from law school, you would be admitted to practice law in your jurisdiction. So this movement has really now become a big national movement, but it very much, as you mentioned, has grassroots origins. So it came to be from one of our co-founders, Bilal. She posted something in a law student meme page on Facebook. And, this was about the time when we were sort of wrapping up law school, right? Our last semester of law school, preparing for finals. Everything was remote. We had been kicked off of our law school campuses, right? Everything felt very much like chaos. And she posted something like, there's no way that a bar exam can happen in July, given everything that's going on. And she's like, does anybody want to help to figure out how we can navigate this, specifically in the state of California, because she was seeking admission in California. So I responded to that, and it sort of just grew from there. We ended up writing a petition to the State Bar of California. We wrote then a petition to the Supreme Court of California. And we realized that it wasn't just California that had to deal with this issue, right? There's bar exams in so many other jurisdictions, most jurisdictions. So we started to make templates of the documents that we were using to try to convince our state bars and Supreme Courts. And folks were picking that up in other jurisdictions. We very much learned so quickly that having this be a national movement of applicants was incredibly helpful in terms of sharing resources, talking about strategy, figuring out how we can get the ball rolling. And actually, Efrain up in Washington had made this awesome survey for applicants, collecting data on how would a bar exam administration impact applicants. And then he shared a template of that survey, with us in California and with other jurisdictions. So this really has grown. It is now not just applicants or recent graduates, it's professors, law school deans, employers, sometimes specific members of state bars or Supreme Court justices that are really acknowledging that diploma privilege is sort of the only equitable solution, the only solution that makes sense, given that we are navigating a global pandemic.
And how do you see the response being to these petitions that you're sending out into the broader movement? What kind of reaction have you seen, both from the people administering the exam as well as from professionals that are already in the legal profession, fellow students? Tell us what kind of response you've seen.
I mean, I think especially from applicants that are the ones that are going to be directly affected by any decision by the Supreme Court in their jurisdiction recognize that this makes a whole lot of sense, right? So the folks that are going to actually have to sit for an in-person exam that is a public health risk, or folks that are going to have to figure out how to navigate an online administration of the exam, are largely in support of diploma privilege. We have thousands of folks just in the state of California that have signed on to our petitions, and that number just amplifies incredibly when you look at our movement on a national scale. We have advocated a ton, especially in the months of like March, April, when COVID was first really disrupting a lot of our lives. And we were surprised to find that professors were getting on board. A lot of deans of law schools in particular states have come out and supported diploma privilege. I know that's the case, for example, my law school is in Massachusetts. All the deans of Massachusetts law schools wrote a letter to their court in support of diploma privilege. Here in California, the deans of all the ABA schools in California came together and submitted a letter to the Supreme Court in support of diploma privilege. That's not to say that there aren't folks that really hang on to the tradition of the bar exam. I think that's something that we have seen with a lot of state bars and a lot of Supreme Courts when they're trying to figure out how to have a licensing scheme during such unprecedented times and being so tied to tradition. I think, we've really had to work really hard to have state bars and justices start to think about, what are other ways that we can do licensing? How do we think outside of the box? How do we come up with creative solutions? And some courts are listening. Efrain can talk a little bit to what's going on in Washington because they actually have diploma privilege.
Yeah, well, Efrain, why don't you tell us more about what's going on in Washington and how you think about the path forward with this issue?
Certainly. So Washington State was granted the option of diploma privilege for July and September registrants of the bar examination if you were a graduate from an ABA accredited law school. That order came down, I want to say June the 12th or June the 14th. I apologize for not having the exact date on hand, but it was presented as I said, an option. So you can either take diploma privilege, and if you fall into that category of folks, you can be licensed to practice in the state of Washington pending your approval, character and fitness, and all the subsequent requirements, or you can sit for the UBE. It's interesting because Donna kind of alluded to this in the reaction we're getting from Supreme Courts and bar associations, is that the bar exam is loved and hated throughout the legal community, but the response that we're seeing overwhelmingly is that courts and bar associations are not ready to see it go. It's very much their baby, and so our advocacy has taken kind of two approaches here. In the near term, we're looking for emergency diploma privilege. That is COVID-19. With COVID-19, there's no way to shoehorn a standardized test that requires hundreds of people in the same room. There's no way to make that happen. So why are we trying to make it happen? Let's get creative. Let's do diploma privilege. There are some states like Utah has a diploma privilege plus model to address the concerns that state bars have about protecting the public, there's a supervised practice requirement as well. But moving forward here in the state of Washington, I think we're really embracing this as an opportunity to evaluate what is the worth of this bar exam. We know what we think, we know what we want it to do, but there's very little data out there to suggest that the bar exam does exactly what we want it to do. There's assertion after assertion that it protects the public, it measures competency, but there's no way to measure that against those who didn't take a bar exam really. And in fact, there are mechanisms like reciprocity and comity between states that suggest that after so many years of practicing, you don't need to take a bar exam. So in the state of Washington, we have stood up a committee chaired by one of our Supreme Court justices to evaluate the performance of those, or really to evaluate the bar exam as a whole. My understanding is that part of that evaluation will be doing how my cohort, folks that came in sans the bar exam, perform relative to our peers that did take the bar exam. Did that answer your question? I think it did. Sorry, it was a roundabout way.
Oh, it did a great job of answering the question. And when you look at the maybe the short-term reality that's ahead of us, we are seeing a lot of states, push forward with the bar exam, making what seem like in some cases pretty surface level changes to how the exam is being administered to account for COVID-19 that are in many ways still putting the folks writing these exams at at risk, and seem very bullheaded about proceeding with the status quo or some minor variation of the status quo. So can you give us a broad perspective, as without necessarily going through every state, maybe which kind of broad categories you're seeing states fall into in terms of how they're approaching the exam? Some states like Washington are going the direction of diploma privilege, but it feels like Washington's in a real minority. What kind of breakdown are you seeing, and where do things stand as a rough breakdown of which states are landing in each of those categories?
Sure.
Yeah,
So
well,
there's, you want this? So there's on the extreme side is the diploma privilege, and so 4 states currently have diploma privilege in some capacity. That's Washington, Utah, Oregon, and Wisconsin. And Wisconsin is they don't have a bar exam. It's just if you graduate from in-state schools, you can be admitted to practice sans the bar exam. From there, it's kind of a sliding scale spectrum, if you will. And the most recent trend that we're seeing, though, is that states, whether they're UBE jurisdictions or not, are canceling their in-person administration of an exam, or adopting this UBE light online exam in October. And this is pretty problematic for a lot of reasons. In general, postponement of the exam means a lot for those who are relying upon the assumption that they'll be working by a certain date. But there's a public concern here as well, given that most states have closed their courts to jury trials. So there's a backlog of cases that need to be heard. In the public sector, especially, there was this assumption that there's going to be a bunch of fresh-faced attorneys coming into the field to pick up the slack, because turnover in public defenders' offices and prosecutors' offices it's pretty high.
Right.
And so postponement is largely seen as a way to kind of ride out the storm and then transition to an online exam. And I'll let Donna talk to the specific problems with online examinations the California team's been better at. But postponement, there's cancellation, there's postponement, there's extension of Rule 9, or in Washington we call it Rule 9. It's a student license to practice law under the supervision of an attorney, which is kind of seen as a compromise because it gets people in the courtroom, it gets people practicing law. But the vast majority of jurisdictions, you are treated as like a student intern. If you are paid, you're not paid as an attorney. So the assumption that you're working and making attorney salary in the fall after you graduate is no longer valid. You're certainly not getting the same benefits as an attorney. Your bargaining power is not the same. And from the employer perspective, I now have to bring someone on board, treat them as kind of an attorney, kind of not an attorney, with the intention that at some point they're going to have to take a bar exam, which, if they're doing it right, is going to require 8 to 10 weeks of studying. That disincentivizes my hiring from the class of 2020. If I'm an employer, I would much rather hire someone under the student licensure model from the class of 2021, knowing that I don't need to give them a break any time of the next year, whereas with the class of 2021 graduate, I do. So that's kind of what we're seeing, is there's a large spectrum once we get away from diploma privilege between cancellation, postponement, and cancellation. But a lot of states are picking up this UBE exam that doesn't give you a transferable score, but is offered online. And I think that's probably a good transition point for Donna to talk about the specific issues with online administrations in and of themselves.
Yeah, go ahead, Donna.
So I was just going to add one more big category, Efrain, on that big spectrum is the in-person exams, right? So there's like diploma privilege, and then there's like online administration, online and provisional licensing, and then there's in-person exams. So there's still jurisdictions that are hoping that this month or at some month in the future, it's going to be possible that folks can do an in-person exam. Some folks have this exam like in a week or something. And for a lot of jurisdictions, they had to sign liability waivers before they go and sit for the exam, because a lot of them are they're generally in convention centers. You can have hundreds, if not thousands of folks sitting in a convention center taking this exam. So there's a liability waiver. Folks have sort of tweaked rules here and there to quote unquote like accommodate for COVID-19, right? Which some of them are just silly. Virginia, for example, says like, due to COVID-19, you no longer have to wear a tie to come take the exam. What the relationship between a tie and COVID is, I have no idea, but just little things that they're doing to try to offset COVID. So that still exists. To the online administration point, I think a lot of jurisdictions, they really want to hold on to the bar exam, but they're also trying to balance all these very real and valid arguments that an in-person exam before any sort of vaccine is available for COVID is going to be a massive health risk. Folks, who have symptoms for COVID might sit and then infect everyone, right? Or, they might, if they're immunocompromised, they might decide not to sit for the exam, right? So there's all of these issues. So they're trying to have it be an online exam. It is not, it's not going to work out for everybody, frankly. At least here in California, there's been a lot of arguments that folks just don't have the infrastructure in place to be able to take an online exam from their house for 2 days. So things like making sure that you have access to internet when you have to log in and out of the exam portal, making sure that you have a working laptop with a working webcam. It can't be an external webcam. It has to be built into your laptop. Making sure that you have like your own space or room that no one is going to walk into, like your pet can't walk in, your mom can't walk in, no one can walk in for those 2 days. Making sure you have nothing on your walls, making sure that it's quiet because the proctoring system will pick up noise. And then especially concerning for folks is if you've requested an accommodation for a disability, it's sort of in limbo how that's going to be treated for these online exam administrations. And with this sort of remote proctoring software that a lot of jurisdictions are using, it's like running the system on your laptop that is checking, your eye movements, your body movements, sound. So for folks that are, that have disabilities and they're taking the exam and their physical manifestations during the exam might not comport to what the software thinks is a typical movement during the exam, they're going to get flagged. And then they're going to have to be like reviewed later for cheating. So it really is a big mess. Also, you're not going to be allowed to have scratch paper. For anybody that I have Barbary technically as my test prep. They're always having us diagram things on physical scratch paper, so not being able to do that. So there are a whole host of issues that come with an online exam. At least California Supreme Court tried to kind of recognize this by saying, if you have any of these accessibility issues or infrastructure issues, then just rely on law schools in your area and they will provide test space for you. I don't know. I haven't heard from any law school saying that they're going to be providing test space for us. It was a recommendation by the court. It's not like law schools have to do that. And, if you're going to go to a law school, that's you going in person, right? And so I think disproportionately folks with disabilities who are concerned about an online administration, they're going to be asked to go take an in-person exam somewhere, which might just trigger aggravating disabilities, right? If they're immunocompromised or something, then they're going to have to opt for an in-person exam. So, at least on our end, even though a lot of jurisdictions have made these decisions to switch to an online exam, folks are still fighting, right? We're still advocating. We're still raising these issues and these arguments. In California, there was a meeting this morning with the State Bar of California. We all called in. So this is all still happening. Just one final point. I think, the fact that there's so much going on in different jurisdictions, that there's different approaches, means that there's sort of different strategies and responses, right? Different arguments that are being brought up in every jurisdiction. So even though we're a national movement, we are a movement that has particular teams in almost every single state in the United States, because it's kind of this effort of we have a national vision and this is a national movement, but our responses are so state and jurisdiction specific.
So as a default in the advocacy you're doing, is there a standard recommendation you're making to states that have to navigate this challenge in terms of which of those paths forward makes the most sense right now, given the current state of the COVID pandemic?
So, our stance from the get-go, this is from March of this year, has been diploma privilege for all of those folks that were registered to take what was formerly or still is the July 2020 exam. That includes, I think as you read at the beginning, folks that are retaking, LLM students, whether you're from an accredited or unaccredited school, because all of these different like alternative pathways, right? Provisional licensing or having to take an online bar exam, they're not fair to everyone. They're not going to, the impact on different groups of people isn't going to be equal. And because, we don't feel like the fact that you come from a low income background and you don't have the computer that fits the conditions, or the fact that you live with a number of family members, or the fact that you're immunocompromised, that shouldn't stand in the way of you being able to get licensing, right? Licensure in your state. And so we really advocate for a broad application of diploma privilege. I don't know, Efrain, if you have anything to add.
I think you hit the nail on the head.
Excellent.
So when we, so that's the logical path forward for exam takers this July, or prospective exam takers. As we think more broadly about, the post-COVID bar exam world, and it feels like the coronavirus crisis has prompted a bigger discussion about the general utility of the bar exam overall, and has caused some to reconsider whether this is something that should exist in the first place. There's been many interesting discussions about maybe the unintended consequences of the bar exam, some of the ways it's promoting and maybe promulgating inequality and injustice in terms of who's admitted to the legal profession. Where long-term, independent of COVID-19, would you like to see the bar exam evolve into, or maybe evolve out of existence overall? Can you share your perspective on that?
Yeah, so we know that the bar exam is racist. It's debated whether its intent is to be racist, but what is undebatable is that its effect is racist. And that's something that the NCBE has acknowledged in their April white paper that pushed back against the idea of diploma privilege. That's a non-starter for us. That's a non-starter for this profession that holds itself up to be one that promotes things like justice and equity and all things that are good in the world. So I think, and we have not, truthfully, we have not distilled this down into a tagline yet, but in our most ideal world, the bar exam is not the barrier that it is today. There are pathways to licensure that don't include a bar exam, whether they're more apprentice-based, something more akin to how medical professionals advance and transition from their education to their careers. Maybe the bar exam looks like a board, kind of how medical boards work, but not a barrier to entry altogether. Maybe that's what it looks like, but the bar exam as a necessity, as it is, as a monolith as it is today, in our ideal world, it goes away. But we're also mindful of the fact that there's no completely undoing the traditions as they exist. So I think that's generally. Am I hitting it? Am I getting that, Donna? That's.
Yeah.
Well, you have to add to that, Donna. Curious what your perspective is, and in particular, I'd love to either from you, Efrain, or Donna, some of the background, maybe the history of the bar exam, and what some of those roots around the bar exam that are racist are driving inequality. You referenced a white paper that detailed some of this. I would love to hear a bit more, and we can certainly link to some of these resources in our show notes as well.
Yeah, so I can let Efrain speak to the NCBE white paper. I will say that there also exists a paper that talks about what really are the origins of the bar exam and school accreditation. Like Efrain mentioned, there's debate of whether or not this is accurate or not. But one argument is that the origins of the bar and school accreditation were that back a century ago, minorities, whether it was a racial minority or women, were starting to think about entering the legal profession. And these sort of obstacles, right, to licensure were put in place so that the profession remained male and it remained white, because the folks didn't want the profession to be tainted, right? They wanted their prestige to be there. And if we let people of color, we let women into the profession, that would downgrade the prestige. So, that's one argument for why we have the bar exam, why it's continued to this day, why we have school accreditation. And whether or not that is true, the one data point that I saw a few weeks ago in California really is so abysmal and disheartening. So, the last administration here in California was the February 2020 exam. Out of the February 2020 exam, from Black test takers who graduated from ABA schools in California, 5% passed the bar exam. 95% failed. That is ridiculous. I mean, overall, the passage rate for that bar exam was like 26 point something percent. So it's just, and I know there are differences between like February administration of the exam and July administration of the exam, but the fact that in February, the vast majority of people are failing the California bar exam after they've studied the law full-time in law school, I don't think goes to say that there's something wrong with law school graduates. I just like, what is wrong with the tests that most people are failing, right? So, that's something that was really concerning. And that actually was the reason why a lot of legislators, at least here in California, wrote to the court, because they were so appalled by this data. And I think that, with this sort of what folks are calling like reemergence of the civil rights movement, there are folks that are constantly and always working on a number of civil rights issues. So I feel some type of way about saying reemergence, right? But with the visibility of the movement for Black lives recently, a lot of jurisdictions, state bars, Supreme Courts, they've come out with these sort of really what seems like not like, I think from my perspective, ambitious, because I don't, they stick to tradition so hard, but talking about how they're going to combat systemic racism and inequality, and they're going to really do their best to see how the legal profession is perpetuating that. They came out with these statements late May, early June, and it's just funny to see that juxtaposed to the data that I had just, mentioned due to the February 2020 exam, right? It's sort of like this bar exam and other facets of school of licensing, like, school accreditation, whatever, they are systemic and institutionalized racism, right? So at the very least, I think that this entire movement, I hope, and I think it has, got the conversation rolling and is building momentum for rethinking these barriers to entry for our legal profession. And hopefully, we'll see it in a place like Washington, thinking through like, what's a very different way that we can have licensing to the legal profession? Because we hear time and time again that the bar exam isn't a metric for whether or not you're going to be a good or bad or competent lawyer. The bar exam, you cram for a couple of months, you take the exam, and then you forget a lot of the information that you crammed for. The fact that, folks aren't going to practice in all the areas of law that the bar exam is testing, right? So are there other ways that we can think about how we can get licensure? Maybe that means clinical credits at your law school. Maybe that means you have to take on real clients, you do mock trials or negotiations, whatever. But thinking through like, what's a better way to do this?
I do have that white paper up. It's a white paper published by the National Conference of Bar Examiners, and it's dated April 9th, 2020. The specific quote that I was talking about is, and I quote, "It is true that differences in average performance on the bar exam tend to be observed across racial ethnic groups," end quote. I think that says it right there. We can do better, we must do better. So our advocacy now, again, is centered on the absurdity of administering a standardized test in the format that we administer it in COVID-19 and the pandemic. But in the long term, that's not okay. That is not for us to accept as we enter into this profession, that it's okay. We know this test is filtering people along racial ethnic lines, but we're okay with it because the white paper goes on to explain that same or greater differences in average performance across racial ethnic groups also tend to be observed in law school GPAs and LSAT scores. I'm taken aback, frankly.
Yeah.
That's not why I got into this profession.
Well, it seems really straightforward. If you want a diverse and inclusive profession, you can't have an exam that is not both of those things, that serves as a gateway into the profession.
Precisely.
Yeah, I mean, I will add one thing. I think at least in California, I don't know about other jurisdictions, um, uh, entities are very clear that at least in part, the bar exam is meant to control like the supply of lawyers, right? There's this idea that there's just way too many lawyers. And so the bar exam is some way to make sure that we control that supply. To me, that's ridiculous, right? Like having folks go to law school and taking out thousands of dollars, hundreds of thousands of dollars, right, in debt, and then being like, "Ooh, yikes, we have too many lawyers. We can't let you in." That's not about competence at that point.
That seems like the wrong place to be applying the filter.
Yeah, exactly.
After somebody's taken on what's the average 200,000 plus of student debt by the time you're through law school?
A mortgage.
I have 273. It is a lot of money. So having folks do that and then having a mechanism to keep them out of the legal profession feels ridiculous. Also, I think there was some study somewhere that said that argument actually isn't totally true. We might have too many lawyers in the private sector, but we don't have enough lawyers in public interest. A lot of that has to do with the fact that because people have such high loans and public interest doesn't pay a lot of money, folks can't really go into public interest. So anyway, that opens the door to a much larger question around paying for law school and what that means for, you know, how the differentiation between paying public interest and private interest works, but I won't get into that.
Yeah, a much bigger problem to solve, but an important one nonetheless. And as you said, the data, even the World Justice Project data that talks about 77% of legal issues going unaddressed by lawyers suggests that we don't have too many lawyers. We maybe have too few lawyers servicing the broad set of needs that 77% of the population that can't see their needs met with a lawyer are facing.
Right.
So tell us, if the objective of the bar exam is really to assess fitness to practice, what other mechanisms are available to better address that need and to build conviction that this person that is being licensed is going to do a good job being a lawyer? There's around the world a variety of models. Up here in Canada, there's been some fairly innovative models applied that I think offer an instructive lesson for the rest of the world in terms of alternative models. In the research you've done and the analysis you've done of alternative models to the bar exam, can you enumerate what those models are and if there's one that jumps out as the direction we should be thinking, at least at a high level in terms of where we want to take the discussion once the immediate pressures of COVID are in the rearview mirror?
I personally like what Utah's doing. They have decided, minus the requirement that if you were a graduate of a certain ABA accredited law school with a first-time bar passage rate above 86%, that requirement aside, I really like the model that Utah has adopted. Their model is licensure on sort of, they're not calling it Diploma Privilege, they're not calling it Diploma Privilege Plus. We're really not sure what they're calling it, but the idea is you graduate from an ABA accredited law school and you practice your first year with a full license, but sort of on a quasi-provisional status. And in that first year, you have CLE requirements, and you also have, or continuing legal education requirements, and you also have a requirement that you have at least 360 hours of supervised practice. And I think that's wise. It satisfies the public protection notion, the purpose of the bar exam, but it gets people working, and it gives them bumpers so that they're not going out and misrepresenting clients or raising the cost of malpractice insurance for firms because supposedly they're being supervised. So I think that and an emphasis on
it sounds like diploma privilege coupled with what sounds like something fairly similar to the articling program here in Canada, where a lawyer needs to article under the supervision of a more senior lawyer for a year after graduating. It feels like those two things brought together in a way. Is that fair?
Yeah, I didn't know articling was a thing, so now I'm going to go look this up. But yeah, if that's what you say it is, then yes. I think this actually it sounds very similar, at least on the surface, to the articling requirement for lawyers in Canada. I also think that there, ideally, again, if I'm king for a day, a renewed emphasis on experiential learning while in law school. Ideally, no one's stepping into the practice area for the first time after they've admitted to the bar. They've done some work in that field as a student under the requirements and supervisory requirements of the day while they're students before they're ever representing clients for real. And then you have this supervised practice model that ramps up in its own way. But yeah, I think that is the most equitable means of getting us there.
Yeah, I'll echo what Efrain said. I mean, and this is me now speaking sort of in my personal capacity, not on behalf of the org. I would love there to be just more requirements for folks to do clinical practice or experiential learning in law school. My law school had, a requirement you to do something for a semester. I wouldn't mind if that was more than a semester, right? Like I did law school clinics for 2 years while I was in law school. And, I took, for example, I took evidence class. I didn't really learn like the ins and outs of evidence until I actually had trial and I had to like do it and experience it and understand how the rules work in a courtroom, right? Like that's a much better way to spend my time than trying to read about rules that don't feel like concrete or rooted in something real in the legal profession.
Something I've seen firsthand too is the massive gap between what law school and the bar exam equip you to do and the requirements that many new lawyers, especially if they're going out to start a solo practice or running a small firm, the practical aspects of running a law firm, of managing a trust account, of managing client communications, of matter management, of doing conflict screening, all of those types of things, the practical skills of running a law firm are really something else that I think we could layer on with a stronger focus on experiential learning and clinics and the apprenticeship model can help to a great degree with that as well.
Absolutely.
So if our listeners are interested in supporting this movement, getting involved, giving you feedback maybe and telling you why you're wrong and the bar exam's the right thing, I'm sure there's opinions people would like to share. How do they get engaged and how do they engage in a dialogue with your organization to map out what the future of the bar exam might look like?
Yes. So if anybody who's listening would like to help or get involved with or support this movement, or if you would like to present counter arguments, right? You can visit our website at unitedfordiplomaprivilege.org. You will there find the contact information for the national team. You will also find links to our social media if you would just like to get updates. There's also a state page on the website. Like if you're interested in supporting or critiquing what we're doing in a particular jurisdiction, you can go to the state page and you can click on the state that you're interested in and it'll pull up the contact information for our advocacy team in that particular state. So you can absolutely do that. In terms of like ways to get involved or to support, most jurisdictions are still having a bar exam in some way, shape, or form. There's a number of ways that folks can get involved if they're interested. They can reach out to the advocacy team in their state and see what needs to be done. They can write a letter to their state bar or their, Supreme Court in their state. They can write to legislators, right? Legislators have had a lot of pull in this movement as well. They can do that. They can make phone calls to their legislators. We have a number of resources on our website. We also have a resource tab that has, templates for things. You can also always just email us and we're happy to send you any templates that we have. So yeah, that's, our website has a lot of the information that you'll need.
Awesome, thank you. And maybe I'll ask each of you to answer this question on your own, but if there's one takeaway from our discussion today that you'd like to leave our listeners with, what would that be? Why don't you go first, Donna?
I think the one thing that I want folks to take away is that diploma privilege isn't this scary thing that's going to set a number of incompetent lawyers onto the general public. There have been jurisdictions that have been doing diploma privilege. Wisconsin has been doing it. We don't have any data to show that lawyers in Wisconsin are somehow so much more terrible than lawyers in other jurisdictions. And diploma privilege doesn't mean that there aren't still requirements in place, whether that's graduating from law school, whether that's having supervised practice, whether that means you have to take, continuing legal education courses. We're open to that. We're not here to not protect the public. We're just trying to adopt a solution that makes sense given the current situation, and a lot of the ideas that are being put forth by state bars and by the Supreme Courts don't make sense. Having an in-person bar exam or having folks take an online exam from their home isn't going to be fair. So if you're interested in getting involved, again, unitedfordiplomaprivilege.org is our website.
Awesome. Efrain?
So I think regardless of how you feel about the bar exam, whether you're for it, against it, or somewhere along that spectrum, this is a great opportunity for us to understand what this bar exam does or doesn't do for us. And I think we all can agree that if we're going to do the thing, we should at least make sure it works. So diploma privilege is a great way to get a control group out there, obviously with reasonable restrictions and controls in place so that we're not causing harm to the public. Like Donna said, we're not trying to harm people, but this is a great opportunity for us to see how much this bar exam is really doing for our profession. And who knows, maybe in 3 years we'll have a bunch of data coming out from this control group saying that, hey, the bar exam actually does do the thing that we think it does in protecting the public and measuring competency. Cool, we've got data for it, maybe we just make it better. But we think, my position personally, is that in 3 to 5 years' time, the state of Washington, for example, we're going to have enough data out there to say definitively that the bar exam doesn't really do a whole lot in terms of protecting the public and measuring competence. And we will have a decent enough footing to justify not subscribing to this really expensive standardized test that we visit upon applicants twice a year. This is an amazing opportunity for everyone. It's not just for those who don't want to take the bar exam or think ill of it. Everyone stands to gain something from this, and that's objective data over what the bar exam does or doesn't do.
Fantastic. Well, Donna and Efrain, thank you both for joining us today and sharing your perspectives. Really enjoyed our conversation, and look forward to continuing the conversation with you at some point in the future. We'll check in and see how things have progressed in a few months' time.
Sounds good. Thank you so much.
Sounds great. Thank you so much, Jack. Really appreciate you having us on. Take care.
You too. Thanks for joining us on Daily Matters, a podcast from Clio. Rate and review wherever you get your podcasts, and subscribe so that you never miss an episode. Daily Matters is produced by Andrew Booth, Sam Rosenthal, and Derek Boland, and hosted by yours truly, Jack Newton. Thanks also to Clio, the world's leading cloud-based legal technology provider, for supporting this podcast.